turning back to S45, relating to protection from nuisance suits. And we're going to start with Merrill Bent. Thank you for being here.
Thank you. Thanks for having me.
Yes, join us.
Do I sit here?
And identify yourself for the record and.
Great. You and I do have a screen share that I want to do, so I want to make sure that sorted out. Sorry, just give me 1 second. Hi. So my name is Merrill Bent. I'm the managing director at Wilmington, Campbell, Bent and Stasny, which is a law firm in Manchester, Vermont. And I really appreciate the opportunity to speak with you today about the proposed changes to the right to farm law. My law firm has been involved for several years in what I believe to be the only case in recent history to which the farm law has actually applied, the right to farm law has actually applied. The case has been referred to as Airy Point, which is the name of my client. The case that I was involved in is an extreme outlier case, and it was not even a close call that the damage that was involved in that case is not something that the right to farm law was intended to insulate. The court found under the existing law that even if the presumption had applied, which it didn't, that my clients would have overcome it because of the substantial adverse effects on health and welfare caused by the damaging flow of water from the neighboring property. And then the plaintiffs, my clients, also proved their claims of trespass and nuisance beyond that. So the Airy Point case concerned extreme changes to upslope farming fields and practices without any consideration for what would happen to the downhill property or to Lake Champlain. The upslope farm installed 119 miles of tile drainage, which collected and concentrates water and then discharges it from the collection system with high velocity right onto and through my client's land. In other words, the flows of water, the tile drains resulted in flows of waters changing in a manner that resulted in a permanent physical invasion on someone else's property. I want to just show you what kind of water flows we're talking about. I think it's important to have the context here. And this is muted, but this is an area of my client's property. This was actually a trial exhibit that we presented to the court. I don't know why it's a little bit laggy on here, but it was taken after a modest rainfall in 2021. And I emphasize that point because I believe a witness told you yesterday that the video I was going to show you was from an extreme rain event last summer, and that is not accurate. This is from a modest rain event because the entire trial was based on routine water influx. It was not based on wild rain events that occasionally occur. Before the pipes were installed in this area was just a trickling intermittent stream. Now this is what it turns into whenever there is a moderate amount of rainfall. And this is actually happening on multiple areas of the property with erosive forces digging deep channels through large areas of land. And I will tell you that there was an active small farm on this property before these changes occurred, and it impacted that farm's ability to actually do the farming work that they did because it basically divided the property into 3 separate islands that you could no longer cross without actually going out onto the road and then coming around the top.
Zach, question? Go ahead.
2 quick questions, Meryl.
Sure.
What is the time date on this?
November 2021.
And how are you defining moderate rainfall? Moderate rain event.
It wasn't one of these extreme events that we've been seeing lately. I don't recall exactly what the rainfall was on that particular date, but it wasn't one of these like flooding events that we've been
Sure.
seeing more frequently. Oh, sure. So I can.
It's very green.
That's what I was gonna ask. That doesn't look like.
No, confused.
Well, yeah, I mean, that is the date. And, whoops. Here. Now I'm lost where it went. Vimeo. I'm sorry, I can't get oh, I see what's going on here. No, I don't.
This is the least fun part for anyone.
I know, okay.
Don't worry, don't worry. I mean, anyone trying to figure it out, don't worry.
Trying to figure it out when I didn't do it. Yeah, 11:30 is the date stamped on this video from the trial.
Is that the trial date stamp or is it the date of the video?
It's either from October or November. I can go back. I know it's from 2021. The trial was in 2022. So the point being, it was not one of these extreme weather events that we've been experiencing in Vermont. Let me go back and play. I can. Sorry, it's so laggy.
Great Wi-Fi.
So if I can just move on to the other
Yeah, please.
exhibits that I have. So I just want to. So this is an example here of the erosion, the type of erosion we're talking about, where it's like channeling these deep grooves in the property, and it goes all the way down. Oh, it didn't switch to this. All right. There you go. So like I was saying, this kind of channelization in the property interfered with the smaller farm that leased land from Airy Point. The water goes through Airy Point's property and ultimately it does end up in Lake Champlain. And you can see the brown plumes that enter the lake. These are coming through the two stream channels that have been deepened and widened across my client's property. And then that water ends up into Arnold Bay and White Bay on Lake Champlain. Then you can, the brown water is the water that is coming off of the Borsfield Farm property.
It's the same dates.
No, these are not the same dates. These are all different. This one is from June 2019.
The date on it.
So in our trial, we also showed that these huge brown plumes that come into the lake have increased levels of phosphorus and E. coli. So this affects not just the intervening landowner, which is my client, but everyone who uses and enjoys Lake Champlain. And then the other, so this is another image of the plumes going into the lake. Another image of the plumes going into the lake. The contamination in the water causes increases in cyanobacteria, often referred to as blue-green algae, as well as other deposits onto the land and onto the lakeshore. And so it results in this kind of like muck-like substance being deposited on the lakeshore, which was once clear because it just increases the growth of these types of growth in the water. So it prevents people from engaging in normal lakeside activities like swimming because it's not safe, nor is it very appealing.
Is that a water intake or water discharge?
That's the water treatment facility. Yes, it's right near the water treatment facility as well.
And go ahead, Zach.
One other quick question. If you go back 3 exhibits, Meryl,
Mhm.
to the initial plume. This one here. Where is the Vorsevelt farm in this image?
It's over here.
Okay,
And so it's on an uphill slope up here. The water comes down. It goes through 3 discharge points off of the Borsville land. It goes under the road through culverts. And then it shoots onto this land in 2 distinct streams that go across.
I understand. So geographically though, it's not pictured in this image,
Correct.
their property. Okay.
Yes, that's correct.
So the other brown plume that's above that, that's not from their farm?
This,
No. In the in
This?
actual, yes.
yeah,
in
there's another
Champlain.
stream that you can't see that comes this way.
Is
And-
that from their farm?
Yes, it's all from Borsville. It's all from Borsville Farm.
Yeah. If I may, is that their, where they're farming down by the water? Or is that their pasture there, or not pasture, but their,
This whole area was pastured. And so they were moving their sheep around from different point to different point. And they used to be able to cross over the small little stream channel, just walking right over it. Now they have to actually go out to the road, across the road and then down into the other part of the pasture.
so those 2 pastures, for lack of a better word, all the way down through there to whatever that blue thing is there, is that all their property too?
Yes, this is all,
Way down.
yes. Wait, Gary,
Wait,
I think you're getting the
whose property is that?
my client's property.
Okay. so not-
Borsville is not pictured. It's over here.
But it's affecting all that green property that we're seeing.
So do you see this brown?
Yeah, I'm not talking about that. I'm talking about way above,
Over
up
here?
higher, no, towards the water.
Over here?
Yes.
Oh, no, that's not.
That's,
This plume though is coming from a stream that comes like right here. So it stops, Erie Point stops right about here.
okay,
So there's the stream is not, you can't see it in this photo, but it comes right here. Goes behind this house and then out right there.
okay, thank you.
Yeah, just one clarifying question. So this came up in testimony yesterday that your client is currently operating what we would call a hobby farm?
Not anymore.
Not anymore. So there's no animals and they're not fertilizing the land at all?
Correct.
Okay.
Yeah, and I will point out too that Erie Point involved a plaintiff who was raised on a large cattle farm. So my clients value and respect farms and farmers. They understand the challenges that farmers face, and this is not a family that would have complained about a minor inconvenience. The plaintiffs also didn't rush into litigation in this case. They asked for and engaged in efforts to resolve this before resorting to a lawsuit. Before filing suit, they actually hired an expert from Cornell University at their own expense, first to make sure that they were correct in regarding the source of the damage. And then they hired that expert to literally design and propose a remediation plan for the farm so that the farm could easily remedy these by just changing some of the practices, remedy some of these problems by just changing some of their practices surrounding them. And the farm chose not to go down that path. So unfortunately, because the plan was not accepted and there was no alternative forthcoming to resolve the problem, they were left with no other options to protect their property from ongoing damage. Both the laws of nuisance and trespass permit plaintiffs to seek money damages from somebody who's damaging your property in those fashions. But I just want to reiterate too that my clients did not ask for any money damages in this case. All they asked was for the court to order the farm to stop polluting their land and damaging their land. So I think adding trespass under the right to farm protection would basically absolve farming activities, even when their activities physically invade and damage someone else's land. And it could potentially immunize farms who start exporting agricultural waste onto their neighbors' land, such as what is happening in this case. And again, this is the only case Vermont has seen in the last 20 plus years. So it's such an outlier. It's hard to imagine a worse example of something that deserves protection when, it's somebody who made changes. Yes, those tile drains work really great for what they're intended for. But if you're not thinking about how they impact other people, they can cause serious damage. So the point is not that you can't use them. The point is that you need to use them in a way that doesn't externalize your costs onto somebody else. And all the other concerns that I've heard that this law is intended to address have been hypothetical. I haven't heard of any other real cases in which there have been unfounded claims brought against farms that would be protected by the changes that are proposed to this legislation. I also, as a litigator, want to just point out that the law actually, as posed, wouldn't prevent any lawsuits from being filed, or from having the parties have to go through discovery and to trial. This is not a law that would dispose of a case early. You would still have to go through the trial process. You'd still have to go through the discovery process. You would still, and now the plaintiff would have the initial burden of showing that this law doesn't apply. So that at the very outset, they're going to be seeking discovery to determine whether those criteria are actually satisfied when the farm is uniquely in possession of that information. The plaintiff is not. So they would have to seek discovery, and they would be entitled to due process through the courts.
So just a question about that point. Does the required mediation prior to suit not alleviate that?
Well, a mediation prior to suit, all that does is put people in a room to talk. It doesn't require any resolution. And I think that, I'm not sure if folks have spent enough time in court to know, but under our civil rules, mediation is already required. So this just imposes maybe a second mediation requirement early. And there's a reason why people don't do mediation early. It's because they haven't had an opportunity to do the discovery they need to have a fully informed discussion about their relative risks and merits of resolving a suit. So there's already a mediation requirement. This just imposes a second one. I suppose the parties could agree that the pre-suit mediation would satisfy mediation that's required under the civil rules, but they don't necessarily have to. I think it's very difficult to mediate a case before you've had an opportunity to collect information from the other parties. So it may not be a fruitful endeavor to do that prior to filing suit, because you won't have the information you need to know what all the details are and how to resolve it, actually, because that's where discovery can be very helpful.
I guess I would think that information could come out through the mediation process in conversation.
It could, but if you have somebody who's not really invested in that mediation process, there's nothing to compel that. And if you haven't filed suit yet, you don't have the right to compel responses to your questions. So you can send an email, you can make a phone call, you can write a letter, but nobody has to answer you and nobody has to provide that information prior to engaging in that process.
And then
Can I answer your question?
No, go ahead. I'm sorry.
well, if I was gonna ask a question about something other than the mediation, so if you want to follow up.
No, go ahead. It's mine.
Okay,
Yep.
I'll shoot out my hands.
well, I was thinking back to what you were saying about that we might be basing these proposed changes might be based on hypotheticals.
Mhm.
And I'm wondering if you think it's fair to say that we can't know if there have been cases that could have been brought but weren't for lack of resources or lack of knowledge of the legal system or lack of rights, so do you think that's fair to say that?
I would say it's probably more likely that the current right to farm law has dissuaded people from bringing lawsuits, because if they feel that they can't overcome the burden that would be imposed by the existing right to farm law, then that would suggest that it's doing what it's intended to do, which is to dissuade people from bringing those suits. There's already
Not intended, right? It's not intended to protect farmers.
It is intended to protect farmers. I'm saying that it does. The fact that there haven't been very many lawsuits suggests that it's functioning. Right? There aren't people going out there and suing farms because their cows got out. There aren't people going and suing farms because of other, types of sort of what I would call inconveniences. The fence falls down. Those don't result in lawsuits. That's not what gets people into court.
Yeah.
Well, in Killington, there just was a case of,
A lawsuit against a farm for.
yeah, for the cows getting out.
And what happened to that case?
A couple that, was driving through Killington and was speeding, hit the cow and they both died. So
Oh, that-
it was in their favor.
That's a personal injury case. That's completely
Okay.
unrelated to trespass and nuisance claims. That's a very, very different type of case. We're talking about, two stationary properties next to each other and how they interplay with each other.
So just a follow-up question, and maybe you're going to get into this a little bit further, but it just seems odd that the burden is on the defendant to show that they're in compliance as opposed to a plaintiff showing that somebody's out of compliance. And frankly, I don't think it, as I think you do note here, it doesn't significantly change burden on the farmer, frankly, because there has to be discovery, presumably pretty extensive discovery would be imposed to find out what is happening on the farm, whether the RAPs are being followed, et cetera. But it still seems odd having that kind of burden on a defendant to show compliance.
I think that's a really interesting question, but I think I would put that in the context of how normal lawsuits work, which is the plaintiff has the underlying burden to prove in a trespass and nuisance case, we're not involving a farm. Plaintiff has that underlying burden to prove trespass and nuisance. That's the same in this. What we're talking about is special treatment for a particular class of defendant. And so the defendant is saying, well, this isn't a normal case that goes through the normal process. I'm entitled to a special presumption. So that's why the burden is on the defendant to say, hey, I get special treatment compared to the rest of the population. I get to have this heightened burden on the plaintiff if I can establish that I'm entitled to that presumption. So it does actually make sense to have the burden on the defendant when what they're asking for is a special treatment that no one else gets. They have to show their entitlement to that special treatment.
But if, from what I understood, and I haven't had a chance to read the injunction yet, but it's difficult, if not possible, to prove the negative of those standards to show that you're entitled to that presumption.
I don't agree with that reading. I think I would actually really invite every member of this committee to read Judge Teachout's order. It is 30 plus pages long. It provides a very detailed analysis of each of those elements and how she analyzed each one of those. And with respect to the notion that you have to prove a negative, when you're actually in the context of litigation, the facts of the case narrow what the actual dispute is about. So you're not out there trying to prove that you're in compliance with every law in the world. You're trying to prove that you're in compliance with the ones that are relevant to the facts before you in the case. And I know that, in this case, the judge said, well, it wasn't enough. All you've shown is that you don't have any notices of violation. That wasn't enough because there were more RAPs and regulations at issue. And the farm was significantly constrained in what evidence they could present to the court on their compliance because they were under active investigation by the Environmental Protection Agency for Clean Water Act violations. That's why they couldn't show compliance, because they knew that they were under investigation for violating federal law. And that case is now pending before the United States District Court. So, I don't think it's that complicated to demonstrate compliance with the laws that are actually at issue in a particular case, given a particular set of facts that are applicable to a live case in controversy before a court. And that's why we have a live case in controversy requirement to even be entitled to go to court, because you need to have a set of facts that allows you to narrow the application of the law. And that is what happened in this case. I can't stress enough how detailed and how thorough and how thoughtful the court's decision was on this point. And I think that it's been given very short shrift in some of the witness testimony that I've observed. And I think that it needs to be respected because the judiciary following a 6-day trial, did what it's supposed to do, which is issue findings of fact and conclusions of law that were applicable to a particular set of facts. So, and again, I just stress that even if even when the presumption is found to not apply, the plaintiff still has to prove their case. They still have to prove that there's been a trespass or a nuisance, as the case may be, I mean, under the current iteration, the protection only applies to nuisance, but, so I also would want to just point out that I think that this law may be vulnerable as written to a challenge for a violation of at least two fundamental constitutional rights. In addition to posing the potential for a takings claim against the state, which Professor Echeverria will discuss in his testimony. In Vermont, we have the Common Benefits Clause, which secures equal protection under the law for all people in Vermont. And this law is oppressive and discriminatory for a certain subset of property owners in the state, and it inures to the benefit of only a small class of citizens, which are farms who are causing damage to other property owners. Those are the only people who benefit, and the only people who are oppressed by this additional requirement that applies in no other case are people who happen to live next to those farms. And I'd say because there are so few lawsuits against farms in the state, I can't imagine that it can be said that this change is reasonably related to a legitimate public purpose, because there's no real benefit to the broader public for this law. It is, again, only benefiting, especially with the addition of the trespass requirement, it would only benefit farms that are trespassing or alleged to be trespassing. The second piece is access.
Before we move on, okay.
So can we just go back to the tiling or whatever that was said? Wasn't that, if I remember testimony yesterday correctly, wasn't that set up through UVM, the extension, and also our own Department of Agriculture that went along with that?
They did work together with UVM, and I would say that the tile drainage itself, the fact of the tile drains is not what was problematic in this case. The tile drains are effective at doing what they are supposed to do, but they were really designed and first implemented and studied on farms in the Midwest, which are very flat. The land is flat. This was installed on a slope. So you're adding a lot of pressure to this particular system. The problem isn't the tile drains. The problem is that if you're going to, put in some feature of your farm that allows you to more efficiently grow crops, allows your farm to flourish and be better, it doesn't mean that you can externalize the waste on your neighbors. And it doesn't mean that you can push all of that extra water off onto your neighbor's land. So that's where the court did not fault the farm for installing the tile drains. The court faulted the farm for not figuring out how to handle the excess waste that they generate.
So your client is, if I understood it correctly, went to Cornell University and they had a better plan of how to.
Well, I think better certainly has, that's subjective, I suppose, but they had an expert design a mitigation plan that had nothing to do with taking out the tile drains or anything like that. All it would require is certain cropping practices to mitigate the effect of the extra water flows. So they were just asking for them to implement some additional features on the farm lands to minimize the amount of water flows that came off the property so that it was less impactful on downslope properties and to decrease the amount of particles that entered the water stream.
So was there a cost to how much that was going to cost that was being proposed?
It was, yes, that there was a cost. It was, I don't remember exactly what it was. It was a while ago that we last discussed this, but it was certainly far less extensive than the cost of what the farm is suggesting that they would do in the alternative, or would have to do in the alternative. So, I mean, we thought it was it didn't solve all the problems, but it seemed to be a nice sort of middle of the road solution to recognize both parties' issues and to say, hey, let's mitigate some of the damage that's going on my property, understanding that you really can't put the genie back in the bottle with tile drains that have been installed.
Did that mitigation ever happen?
No,
Why?
because the farm didn't want to change their crop practices. They wanted to expand their capacity, not rotate. It was like crop rotation and some additional buffers and things like that. They didn't want to have that dictated to them.
Thank you. Zach?
So just a quick question on, one of the themes that you brought up is, or that you provided testimony on is, impacting on your client's land. And so one of the things that we've seen in exhibits thus far is really the plumes that are coming out into the lake. And I don't think, but I just want to clarify that your client isn't asserting to owning the actual water in Lake Champlain.
No, but I think it's helpful demonstration of where it eventually ends up. I don't think it would be helpful to any of us to just pretend that it stops at the land boundary and doesn't ultimately end up in the lake that we all
Sure.
find so important.
Yeah, no, most definitely. And so
Very important.
Understood. And so
Yeah.
I guess my follow-up question to that is, do you have specific exhibits that you can show where it's impacted your client's land directly? Not in the water, not in the lake, but on their land?
I mean, I didn't include the hundreds of exhibits that, the hundreds and hundreds of photos we have, but I can tell you that this kind of damage that we're looking at right here, it appears all throughout my client's land. There are new stream beds, there are new stream channels, I should say. There are tree roots that have been completely eroded and undermined. The trees are going to fall down. I didn't bring photos of all of those,
Sure.
but they were exhibits at trial, and I can certainly make
As a
a
follow-up, that would be helpful.
compendium of photographs.
Yeah, as a follow-up, that'd be helpful, because I think one of the things that I'm really struggling with is just when I think of, gravitational forces and water going downhill, the thing that I struggle with is how much of this is just, what's happening and occurring in nature. And it seems like the Vorsidals have tried to ameliorate, some of the different paths of water.
I'm not familiar with any efforts they've made to do that, but
But I guess what I'm trying to distinguish is that the best efforts that the Vorsidals have made, compared to what's naturally occurring in nature. So I guess it would be helpful if you could try to provide some kind of distinction of like what's naturally occurring and what has been done directly as a result of what the Vorsidals or what the Vorsidals have allegedly done.
that's, yeah, I understand what you're saying. And obviously we all recognize that there is naturally occurring water that would exist no matter what happened. So we're just talking about the fact that there is the way the tile drain system works is that it quickly, drains the water and then it collects it into a tile drainage system and then it concentrates it into a particular direction. So it's no longer a surface spread that kind of like winds its way down the surface water path. It is something that is being like shot through a piping system.
Okay.
But I think that the question that you're asking is a really important one, and I will be happy to provide additional photos. But again, it is one that is addressed at great length in Judge Teachout's decision on this.
And I'll be reviewing that.
Yeah, because
Yeah.
it is incredibly detailed, and I think that it will shed a lot of light on just sort of what the facts were that were found by an independent member of the judiciary, as opposed to two different parties with two different views.
Right. Well, and that's the thing. It's like
Yeah.
two different sides of litigation. And one other quick follow-up. What is your client looking at in terms of KPIs of like where they would feel like the sufficient progress has been made to either stop litigation or to come to some kind of compromise with the Vorsidals? Like, is it water clarity? Is like one of the things that was brought up in testimony yesterday is like manure happens to smell, and so like it's a very hard thing to quantify and measure like how bad does something smell versus, relatively to something that doesn't. So like what KPIs is your client thinking through and are they looking at?
So at this point, as I mentioned, my clients didn't bring any claim for money damages. They're only seeking injunctive relief.
Sure.
We are primarily focused on the water issues, and that is both the inflow of water, the velocity of the water, and the quality of the water. But at this point in time, we have a specific injunction from the court. So all they are looking for now is compliance with that injunction.
Okay.
So,
Thank you.
Yeah.
So I have lots of questions. I have Ken and then Tom and Ian, but before that question, so it's kind of interesting because we're not here to litigate this case, but it does inform what we're looking at,
Right.
which is really interesting because we have this real life example and we're looking at how this law might impact something like that,
And-
for future, but I just.
Just to be
So it's kind of
clear, my
interesting.
position is that it shouldn't really inform because it's such a outlier,
Okay,
extreme example of the kinds of things that come up.
but we also don't have that many other examples
Right.
where this has been tried in court, so,
Right.
so that's, yeah.
The law is working.
Right, because you say the law is working, that's which was, but we've had contrary testimony on that, but Ken, then Tom, then Ian.
So. So I'm just gonna start at this picture right here.
Mhm.
I'm looking at riprap that's been put in there after, or I mean, before that damage there, right?
No, that riprap was placed in after the damage started, and that riprap didn't start there. It started up by the road and it washed down the channel after as a result of the ongoing flows from the Worsfield Farm property.
You're saying that riprap didn't start there, it
Right.
washed down from up above?
From immediately above this fence, yes. It's not, the town put a bunch of riprap in to try to like shore this up, and it got washed out pretty quickly.
That's interesting. So my next question is, I assume because the farm is taking this all, I believe themselves, all the water is originating from their farm?
Do you mean, well, I think, again, I would direct you back to this judicial decision, which talks about how there are different types of sources of water, but how the installation of the tile drains has increased the amount of water exiting the property. So no, it is not all originating from the tile drainage system, but the fact that it has increased the volume, the amount of water, and the velocity with which it leaves the property is what causes these issues.
So I guess what I'm trying to understand is, has the water, so I think what I just heard is there's a lot of water that's probably coming from other land that's flowing onto this existing farm. Has that water
I don't think.
flow been increased?
I don't think that's quite what I said. The water flows that enter Erie Point are all coming from discharge points that are coming off of the Worsfield property.
Right, the water is there water that's flowing on I can't pronounce the name, that property, the
The Worsfield?
yes. Is the water just coming from their property or is it flowing from somewhere else?
I mean, in the sense that there's always flows of groundwater from different directions, I think, you can look at it as that kind of system, and then there's water that falls from the sky that also infiltrates.
I understand that. My question is there more water that's flowing onto the Roosevelt's property than ever before from something that's changed or just climate?
No, the basis for why there's more water is because the tile drain system is removing more water. So it's actually removing water from it. It all infiltrates into the tile drainage system. So it's quicker to dissipate in the farm fields. That's why they're installed. So it's not a function of more water. It's a function of more efficient water removal.
But it's not working because it's not dissipating in their fields.
No, it is working. It's working great. The problem is that the water dissipates quickly from their fields. It's very efficiently removed from the ground system, but then it is very quickly directed.
It's not being absorbed in it.
Right, correct.
Yeah.
Exactly.
Then Ian.
The Erie pasture lands that are distinct. How much drainage tile is in there?
None.
Are you sure?
You mean tile drains? We don't have tile drains there.
Not trying to-
Not to my knowledge.
Okay.
I mean, are you being specific about tile drainage, or are we talking about culverts?
Tile drainage.
Yeah, and not that I'm aware of.
Ditching.
Tom, what was
I'm
your
just-
question again?
Yeah.
I'm sorry.
How much tile drainage is on her client's pasture land?
I'm not aware of any.
Oh. Just the imagery looks like there's an awful lot of satellite.
Of tile drains?
Yeah, you can see it. I can see it on both North Pets and
So
It looks like,
Yeah, I don't think that's correct, but
and it connects to those same two streams that spill into.
presumably that would have been brought up as.
Yeah, I would think so. I'm just curious because it's,
yeah, I've never heard of
so it
that.
would be a contributing.
So not retrying the case, but.
Right.
No, it's very interesting. though.
It is very.
Yes. No, I understand. Yeah.
Hi, Mel. Yeah, I'm enjoying the like very specific questions on the game. But trying to.
Well, I'm glad
kinda-
one of us.
Trying to kind of get us back to the bill a little bit here.
Mhm.
Something that's come up and I think is an interesting nuance that didn't really come up yesterday. So, my question is kind of like trying to clarify it for myself because I don't know very much about this area of law. So currently the presumption for a protection for nuisance lawsuits in existing law doesn't include trespass.
Correct,
It's just nuisance lawsuits.
correct,
The proposal for the bill would be to add trespass as well.
right.
So in your case, to not get into specifics, you brought a separate trespass claim
There
as
were-
well.
There was trespass and nuisance claims.
Okay.
Yes.
And did the court talk about applying the nuisance protection to the law, to the trespass at all?
Not to the trespass.
Okay,
No,
so-
it was distinguished.
Just, yep, okay.
Yep, but there is some overlap between nuisance and trespass claims. So
Yeah.
something that constitutes a nuisance can also constitute a trespass and vice versa. So there is some overlap, but it's not a complete overlap.
So,
To be clear.
yeah, and I'm just wondering, as we're taking considering S45, if like one of your concerns was including the trespass, if we took the trespass out, then now we're talking nuisance again, which is its own thing. The water flow issue, the continuing trespass that exists there,
Right.
you would still be able to pursue that claim even if we were to change the way that the nuisance law is structured.
Mhm.
So I'm just, so I guess I understand that. And then my other question was for the nuisance side of the water flow, not the trespass side of it, which of the existing 4 subsections did Teach Out use? Was it
Do you mean which of the 4 of
say that it was violating so that it couldn't apply the
So-
protection?
I have to be like very clear about how this is presented. But the Judge Teach Out found that they were unable to satisfy 3 out of 4
Yeah.
of those requirements.
And I read through it and but wasn't specific about which one.
It was A, B, and D.
But and was that
Oh, I'm sorry. No, that's wrong. It was A, C, and D.
A, C, and D, and that the water flow for the nuisance was violating all three of those?
So it's not. I wouldn't say that the law is quite structured to say that it's violating all 3 of those because you just have to say, because when you're talking about whether you're entitled to the presumption, you're talking about the farming activity.
Yeah,
You're not talking about the impact yet.
yeah,
So you're just talking about whether the activity in question, the one that is being complained as the source of the problem,
yeah.
meets all of these standards.
Mhm.
So it is by the nature of the facts of a case, you narrow down what the actual issue is. I really don't agree that there's this like, you have to prove a universal negative component to it because it's just not how matters work their way through the courts.
Okay. Yeah, I'm just wondering, I'm just trying to think, it is so hard to not apply this specific case to what we're trying to decide here because there's nothing else to work with.
Yes. And I did hear some discussion about another case that went to court. I didn't catch all of the details, but it had something to do with a zoning case. So I understand that there was another farm that said that they were concerned about having to deal with cases in court, but this has nothing to do with zoning, the application of zoning bylaws. It has nothing to do with zoning appeals. So it wouldn't prevent people from going through that land use regulatory process that exists in other contexts.
Final question, just again on the trespass versus nuisance. Let's get like rid of farms entirely and just talk about generally those two claims. What is the difference between the two of them as far as like damages, or are they fairly similar, or
It really depends on the damage that was visited upon the receiving party. And like I said, we didn't pursue that. So it hasn't been an issue that I've been dealing with because
Okay.
there was no claim for damages here. There was no claim for damages. This is, this was purely an injunctive relief case. Please stop dumping your water on my property. That's it.
Yeah.
That's all it was. It wasn't, please pay me millions of dollars or whatever because you're damaging my property. It was, can we stop this so that we can try to shore up the damage that's already occurred? They weren't even asking for remediation of the damage that's already occurred. They were just asking to stop.
Tom?
Our language is proposed, would that have prevented from being able to file a claim? Or
Prevented from filing a claim?
or filing suit?
No.
You still would have been able to.
Anybody, this doesn't stop anybody from filing suit.
Right,
Yeah.
I guess getting it to the point that it's at now, or would it have changed the scope?
I can't exactly say that because, that wasn't how the evidence was shepherded through this case. I certainly think that's the idea behind it. But, like I said, I find it hard to imagine that this is the kind of ongoing property damage that we would want to insulate, and really just impact a very small group of Vermonters who are just people who happen to live near ponds.
Just be pursuing that just a little bit further. So, let's put aside this case. Let's use a hypothetical case.
This is all I know.
So somebody has a property and they have water coming from a farm next door. They bring the lawsuit. I'm talking about if we pass the bill. They bring the lawsuit and claim nuisance and trespass. And then they seek discovery, presumably, to back that up. The defendant, the farmer, says, well, this is a practice conducted in a manner consistent with proper and accepted customs and standards followed by similar operators of agricultural activities in the state. Under current law, there seems to be a burden on the defendant right then to back that up.
Mhm.
But instead, under this law, they're making that claim. And now you have to disprove that. And you have to presumably get discovery to say that you have these RAPs, required agriculture practices, did I get that right? And that they're not following, and you'd have discovery and you'd have the burden to show that in fact that's not the case. So it's just like the burden shifting here of who should have the burden of either showing that they're not following the practices or they are following the practices. And I can understand on the one side that the defendant farmer has the information on whether they are following those practices or not, but that's information that you could get through discovery.
Right. But
So I'm trying to
they're
see
also
where-
asking for, the reason that the presumption is the way it is because they're asking for special treatment under the law. So it makes sense that the person who's asking for special treatment would have to show their entitlement to that special treatment. Nobody else gets the presumption that trespass and nuisance claims are, under the current version, that nuisance claims can't be pursued against them. That is a special provision. That's why the person who's trying to invoke it should have to establish that they're entitled to it.
Right.
But what you've established here is a pleading standard, okay? In the law that you're proposing, what you've established is a pleading standard. So the plaintiff comes in and they say, we don't think that they have done these things. We don't think that they violated these things. We want discovery. We're going to go through the due process that we get in this court process. And I have to believe that, they'll present the evidence that they get from that discovery process, but the defendant is also going to have to rebut it, right? So, I mean, effectively, does it really change?
That's what I'm saying. I mean, it's just like a pleading practice is what we're dealing with. Ultimately, all that hasn't come out.
But I guess that's my question is you currently have a provision that is not that dissimilar from the structure that you're talking about, there's sort of a burden shift, but it doesn't have a practical effect. We know that there haven't been significant amounts of nuisance lawsuits against farms to which this law has even applied. And you want to introduce the level of uncertainty that this bill would introduce in potentially creating unintended consequences for a problem that we don't know actually exists.
So, Angela.
I think I was gonna ask the same question, like, walk us through, you know, either your case without details or a hypothetical under the new proposed construct.
It's a really good question, and I think it's exactly what your committee is wrestling with. But I have to say, when you have a provision that sort of upends a legal structure that is rooted in the common law that has existed since the beginning of time, and you're sort of like upsetting that, how many unintended consequences are there going to be when push comes to shove, and these things actually get litigated. The other, actually, I didn't get to point out that I think that there's another potential problem with a constitutional infirmity for another fundamental constitutional right, which is the right to access the courts. And if you're imposing a cost on somebody to engage in a mediation process before they go through the court system, and there is no provision to relieve them of that cost, you may be depriving somebody of the ability to access the courts to protect their property. And it's a minor point, but I think that there are people whose greatest asset is their property. And how much is it going to cost for them to have a mediation that they don't know is going to be effective? They don't know is going to actually result in anything protective for them. And that they have no way to avoid that expense. And I would also point out that that's not an expense that any other landowner faces to bring an action for damage to their property. It only would apply if you happen to be neighbors with the farm. So, you know.
Yeah, I guess I would say, I appreciate that concern, and I think I'm far more concerned about attorney's fees than in terms of access to justice.
True.
I would be about cost of mediation. That's just setting that aside.
You're absolutely correct about that too. But that's an environmental justice issue as well.
Yeah.
I mean, you're now saying there's an added burden on me to protect my property from like dumping of agricultural waste on it. That could impact, I mean, that goes both ways.
Yeah, and I'm wondering if I hear what you're saying about potential unintended consequences and upsetting, something based on common law. But I wonder if we could also describe this change as updating a very old law, or a law that's based on something, based on laws that are not really fully recognizing our current landscape, cultural shifts. Might this be a shift that is necessary given what we know about the decline in the number of farms and the number of acres in Vermont that are currently being farmed, and just the shifts that are happening. Not assigning any judgment to those shifts,
Right.
but saying because of those shifts, it might be time to update this law to recognize those changes.
I hear your question. I still don't know from the landscape that we have before us what problem it's trying to solve, because there simply aren't lawsuits that this is going to prevent. They simply aren't there. There's one case in the last 20 years, and it is an extreme example. There is not a litany of litigation. And
I'm thinking about the farmer we heard from yesterday who mentioned
it's a zoning case.
a strawberry field.
It's a zoning case. Doesn't do anything. You still have zoning, you still have that regulatory process. I understand why people don't want to end up in court. I get it. Trust me, I see a lot of that day to day. I try to dissuade people from going to court. That's the first conversation I have with everybody. And I'm not giving away any secrets here. I'm not the only lawyer who's first discussion with their client is, are you sure? You know, but that's not going to stop a zoning. This isn't going to prevent a zoning case from going forward. And that's our structure. I mean, that's the structure that we have set up for how we regulate land use. So I mean, I've said everything that I want to say. I really appreciate how thoughtful this committee is about these changes, because I think that they, like I said, could have some unintended consequences. And I'm not saying that a change couldn't benefit everybody. I think it needs to be very considered change in order to accomplish what you were trying to accomplish. And I'm not sure this does what you're trying to do.
Any other questions? Yes. No, go ahead, Ken.
I just want to go back to the water that is flowing on this farmer's land. If that water wasn't flowing there, if somebody was doing due diligence, for lack of a better word, to stop that flow of water that's going on their land, in my mind, as much as I think it is, wouldn't that take care of a lot of this problem?
You're saying if we stopped the excess water from flowing onto the neighbor's land?
Onto the farm, the farm that's being penalized.
I think that would be tricky because it's naturally occurring water. I mean, it's
naturally occurring water, if I understand this right. It was naturally occurring water before, and then the tile system got put in there.
and it increased the impact because it is draining the water much more quickly. It's allowing for more infiltration. It's allowing more water to infiltrate through this system, through a particular system. So it's changing the way that the water flows significantly, and the amount of the water, the quality of the water, and the velocity of the water. It's a big change.
I guess I'm just having a hard time understanding why the University of Vermont and our own agriculture department would allow something like that to happen that would increase the flow of water on other people's land. That makes no sense. It's like putting a turbo system in there to.
We fully agree with you, and I will tell you that the testimony at trial was, we didn't think about it. We didn't think about what would happen downslope.
Okay, thank you.
Thank you. Thanks.
Okay, so we're actually going to jump ahead to Professor Echeverria. Did I pronounce that right, Professor? Sure. And then we'll go to Scott Sanderson and John Groveman after that. Yeah, thank you for being here.
Thank you. Taking me, you put me unawares. I was relaxing, waiting for you. I think I had another half hour to get ready.
I have done that to students in the past, and I'm getting back at you for those times that my law professor, when I was daydreaming, called. So this felt good for me to.
I can share a secret with you. It was good to see Ward Goodenough here. He was in my property class, and he was like me sitting in the back of the class and looking pretty bored. So I didn't bring that up with him today. So
That's fine.
thank you for the opportunity to testify. My name is John Echeverria. On the witness list, I'm identified as a professor at the Vermont Law and Graduate School, and I just hasten to say that I am here in my independent individual capacity, and I'm not speaking on behalf of the law school or as a representative of the law school. I have no position on S45 as a whole and many of its provisions. I'm here to address a single issue, and that is the possible expansion of the existing right to farm law to encompass trespass. And I believe this particular provision, which would represent a major expansion of existing law, would routinely violate Vermonters' constitutionally protected property rights. It would potentially subject Vermont taxpayers to serious and unanticipated financial liabilities, and it would fundamentally change the existing rules governing neighborly relations in Vermont in a way that would be fundamentally unfair and undermine constitutional values that Vermonters hold dear and are entitled to have respected. So I strongly recommend that the committee not extend the right to farm law to trespass. Whatever position the committee may take on right to farm legislation or on this bill in particular, I urge the committee not to expand the current law to trespass. So I think I can be of assistance to you because with all humility, I have a great deal of experience in this area of law, constitutional property rights. I have been a lawyer for 45 plus years. My particular specialty for the last 30 years has been constitutional property rights. I successfully represented the governor in Hawaii in a major takings case in the Supreme Court, and I've litigated takings matters at every level of the federal court system and in the state court system. I've taught property law. I've written books and articles. I've done many public appearances. I've testified in front of Congress many times and before committees of this body. I've received an award from the Department of Justice for my assistance to the United States in defending against takings claims, and I received a Lifetime Achievement Award from the state and local government section of the American Bar Association for my legal advocacy on the takings issue on behalf of state and local governments. I offered that long-winded and self-promotional introduction to say that I think I know what I'm talking about. I mean, people can and will disagree with me, but I know this area, so I think I have something to offer you. The second point is that I'm typically on the pro-government side of these debates. I've typically supported government against takings claims and try to defeat what I think are unjustified and exaggerated claims of property rights. But in this case, I think the government is clearly and obviously, with this bill, threatening to unconstitutionally invade private property rights. And the violation is so egregious and so obvious that I'm perfectly comfortable, given my general pro-government orientation, to be appearing for you to explain why I think this is a taking. So just to step back a bit, I just want to emphasize that I believe all or virtually all Vermonters and U.S. citizens agree on the basic importance of private property rights. In a 2021 decision, the Supreme Court declared that protection of private property is indispensable to the promotion of individual freedom. Moving on, quoting John Adams, the court said, property must be secured or liberty cannot exist. In a 2017 decision, the Supreme Court said property rights are necessary to preserve freedom for property ownership, empowers persons to shape and to plan their own destiny in a world where governments are always eager to do so for them. Now, the U.S. Constitution obviously protects Vermonters and every citizen in the United States, but the Vermont Constitution provides independent protection for property rights. In 1777, when Vermont was still a republic, Vermont adopted the first constitutional takings provision in North America. This provision subsequently served as a model for similar provisions in other state constitutions and in the U.S. Bill of Rights that was adopted in 1791. In a striking decision in 2023, the Vermont Supreme Court said that the Vermont Constitution vigorously protects private property ownership, and Vermont's unique character and traditions support a robust commitment to private property ownership. And for those of you who know your history, the history to which the Supreme Court was referring had to do with a conflict between New Yorkers and Vermont over the land grants and the effort by the dastardly people from New York to steal land from Vermonters. So Vermont was unique among states in that its birth was centered around private property disputes, and therefore the Constitution of this state from the very beginning has emphasized private property rights. The first two articles of the Vermont Constitution, the very first two articles, emphasize private property rights. So against that general background, the U.S. Supreme Court and the Vermont Supreme Court have recognized that certain kinds of actions, certain kinds of government actions cut more deeply, more seriously into private property rights than other kinds of governmental actions. And it's that distinction between the kinds of governmental actions that can adversely affect private property rights that gives rise to my concerns about the potential expansion of the right to farm law. So on the one hand, the courts have recognized that restrictions on the use of property, regulations, or any other kind of governmental action that restricts the use of property can give rise to a takings claim, regulatory takings claim. And the Supreme Court has said Well, in evaluating those claims, you look at a bunch of factors, you do a balancing test, you look at the economic impact, you look at interference with investment-backed expectations, look at the character of the regulation. In practice, there turns out to be a fairly deferential test, and most regulatory takings claims fail. By contrast, the Supreme Court has established a very different standard for so-called physical takings. When the government physically takes private property, the Supreme Court has said the takings clause imposes a clear and categorical obligation to provide the owner with just compensation. One of the principal ways the government can physically take private property is by invading it or occupying it.
But I'm just confused because we're not talking about the government taking property, so
And
just
everything,
wondering how it fits.
sure. And everything I'm saying about what the government's doing is either the government does it or the government passes a law or a regulation and says Joe Public can do it. And whether the government is doing it itself or the government is authorizing members of the public to invade or occupy property, the analysis is completely the same. Okay. So the especially strong protection against government occupations or government authorizations of occupations of private property is based on the recognition that the so-called right to exclude is one of the most treasured rights of property ownership. It's one thing for the government to tell you, you got a floodplain property, you're not going to be able to build a house. That could be annoying. That could be an impairment of private property rights. But when the government comes onto your land, floods your land, dumps equipment on your land, that is, the Supreme Court has said, an especially serious kind of invasion. The Supreme Court has said the right to exclude is universally held to be a fundamental element of the property right and one of the most essential sticks in the bundle of rights associated with property. The Vermont Supreme Court said something very similar last year. One of the main rights attaching to property is the right to exclude others. So I've talked about regulatory takings claims and how they arise. Physical occupation takings claims can occur in a variety of ways. The government can flood property, or somebody acting with government authority can flood property. The government can fly planes low over your land. The government can authorize people to travel through your property. The government can authorize the placement of equipment, wells, cable lines, any variety of things on private property. And all of those things are regarded as physical occupation takings, which are subject to essentially a per se or automatic rule of liability. The economic impact of the invasion, though it might affect damages, doesn't affect the question of liability. In addition, in an important 2021 case, the Supreme Court made clear that physical occupations are categorical per se takings, whether they're permanent or temporary, whether they're continuous or they're intermittent. Now, with all that, how does that apply to the right to farm legislation? The nuisance provision and the right to farm law obviously impinges on private property rights because someone who has a nuisance claim may be barred from bringing a nuisance claim as a result of the right to farm legislation. But the effect of that type of provision, preventing someone from bringing a nuisance claim, is to limit their ability to use their property. Therefore, a nuisance provision and a right to farm legislation implicates the first kind of takings analysis I'm talking about, a restriction on the use of property, subject to a very deferential standard. In my judgment, a nuisance, a right to farm legislation focused on nuisance would rarely, if ever, give rise to a valid takings claim. That is not a universal viewpoint. The Iowa Supreme Court, in a famous, well-known decision, Borman said that the Iowa right to farm law, which focused solely on nuisance, did affect taking. But the Idaho Supreme Court, other state courts have taken a different view, and my view is the Iowa Supreme Court got it wrong. That anti-nuisance suit provisions and right to farm legislation don't implicate the takings clause. On the other hand, if the right to farm legislation extends to trespass, the legislation would frequently result in unconstitutional takings. A trespass is not merely a protection against interference with the use of the property. A trespass claim asserts that the government or somebody clothed with government authority has physically come onto your property, violated your right to exclude person. In other words, a trespass infringes on the treasured right to exclude. And if the law of Vermont prevented somebody from bringing a trespass claim, that would be an authorization to trespass. It would be an authorization of a physical occupation. So applying this doctrine to the Erie Point case, which is the only case any of us know anything about, Judge Mary Teachout has ruled and in an exhaustive decision that the installation of this subsurface drainage increased the velocity and volume of water in a way that constituted a trespass of private property. If the right to farm legislation were enacted to include trespass, the effect would be to authorize a physical and clothe someone with the authority by government to invade private property and violate constitutional property rights. At this point, a landowner faced with the impediment of the right to farm law, if it were amended to include trespass, would be compelled to sue the state of Vermont for financial compensation on the grounds the application of the right to farm law violated private property rights and gave them an entitlement to sue for compensation either under the Vermont Constitution or the federal Constitution. And then after the landowners spent a whole lot of money and the Attorney General spent a whole lot of money I think the claimants, if they had the stomach for the litigation and the financial resources to support it, would end up recovering from the state, imposing significant but hard to quantify financial penalties on the state. Ultimately, the taxpayers would end up paying the tab for the legislature's, in my view, misguided decision to create a right to farm regime that routinely violates the private property rights of landowners. Now, we all recognize that only so many people are going to be able to bring a nuisance suit or a trespass suit, never mind a taking suit against the government, right? So what's so perhaps the Erie Point plaintiffs, who apparently have certain resources, could pursue a takings claim if they were faced with this situation under the new law. But in many cases, perhaps most cases, people would have physical invasions inflicted on them, authorized by government, but be powerless to do anything about them. They would be deprived of their constitutional property rights and be without remedy. So wholly apart from all the litigation and costs that would flow from an expansion of the right to farm law to include trespass, this change in the law would fundamentally change the neighborly relations that exist in Vermont. It would empower farmers to trespass unconstitutionally on their neighbor's property. So to sum up, to avoid imposing onerous costs and other burdens on Vermonters, to avoid expensive and time-consuming litigation, to avoid creating a new legal climate in Vermont that encourage routine constitutional violations of neighbors' property rights, and to vindicate Vermont's longstanding preeminence in the nation in defense of private property rights, I respectfully recommend the committee not extend the existing right to farm law to include trespass.
Tom, did you have a question?
Yes. I got you. Now, I think part of what we're trying to look at here is maybe how about something that's going on pre-existing and then you have a new neighbor? Something that obvious, such as an airport, noise, smell, anything, and someone moves in. I think you understand my question. As far as what is the suits, they can still bring suit, but unless we change policy.
Well, I mean, there's a well-known doctrine of coming to the nuisance, where if there's an established activity and you move into the neighborhood and you say, "Oh my God, this drives me nuts," and I'm going to bring a nuisance action. Under the common law, you would be poorly positioned to bring a nuisance suit, and under the right to farm legislation, you'd be even in a worse position to successfully bring a nuisance suit. I don't think that has any bearing on trespass or physical occupation takings, because the question of investment expectations doesn't come into it when you're talking about a per se physical occupation plan. the physical occupations are the third rail of constitutional property rights jurisprudence. If the government is invading your property or authorizing somebody else to invade your property, it is almost invariably a taking, and it's not going to matter whether the person was, maybe the farmer was invading the property rights of the prior owner, but that's not going to preclude the current owner.
Right. I guess the other half would be, would things like smell or noise also be considered trespass?
No, there's some.
Unless it was a disorder,
No.
a certain hour.
No. I mean, there's some esoteric cases having to do with particles of pollution going across the property line. And is that a nuisance? I mean, the particles go over to annoy the neighbor. That's arguably a nuisance, but when the particles cross the property line and enter the property, is that a trespass? And most courts say, no. Yeah, I suppose odors are composed of molecules. So the molecules come across. No, so smells, noise, any kind of, allegedly unreasonable interference with the property that comes under the rubric of nuisance is in my view, not trespass. I guess I would disagree with Merrill a little bit on the overlap between nuisance and trespass. There is some overlap, but not a lot. I think.
Sounds like you agree with me.
I knew you would be on that point alone, but I think there's a pretty clear distinction. I mean, it's.
Ian, do you have a question? It looks like you had a questioning look about you.
No, I think, well, yeah, I guess it sounds like we should probably take the trespass out. At least that's kind of where I'm thinking. My question, so if I could sort of use your experience and knowledge here for just a more general understanding for the committee on this bill. Are there other examples when it comes to property rights where a presumption, a protection, the burden is put on a plaintiff seeking a claim versus a defendant asserting it?
The law is so highly variable in that who should have the burden of coming forward with evidence and establishing a point. And I guess I would just say the law is all over the map on that. Often it turns on who has the access to the information. I mean, if the information is within your possession, well, then it makes sense to ask you to prove the point rather than ask the other party who doesn't have the information to show that the point of information exists. I guess I would endorse Merrill's sort of general point that the plaintiffs always bear the burden of proof in civil litigation, and appropriately so. And then, of course, if defendants have affirmative defenses, they bear the burden of proof. The right to farm legislation is a special kind of legislation that says that there are a class of people who are going to get out from under the ordinary rules of nuisance doctrine, and that those persons are going to be able to engage in activities that could be construed as unreasonable interferences with the use of property that would give rise to nuisance liability in other circumstances. So the right to farm protection is a pretty valuable privilege that's being extended as a special exception to a special set of beloved members of our community. I'm a farmer. We like farmers, and I understand the rationale for it, but it is an important exception to the ordinary rules, and it's a special benefit. And I think the notion that the person claiming the special benefit or the immunity from the ordinary rules of liability ought to have responsibility to show that they're entitled to it.
And so just to follow up on that then, setting trespass aside, I think Merrill's point on the common benefit constitutional issue around the burden being on the plaintiff, do you think that there could be
I know nothing about that topic.
Okay.
I'm not I'm not here. I have no.
You got nothing. You got nothing. Okay. Thank you.
Angela?
Well, I don't know, but maybe this is going further down the road that you don't want to go down, but what you just said made me wonder, saying that, and Merrill brought this up as well, that farmers being in this special class that we've designated, that it makes sense at the that's a fair paraphrase. It makes sense then that they would have an additional hurdle or burden, perhaps.
It's not, if I may.
Yeah.
I wouldn't characterize it as an additional burden. I would say there's legislation, exceptional, unusual legislation has been enacted in the form of right to farm law that says, with respect to our beloved silviculture and agriculture, I don't know if it applies to silviculture, does it?
Not in Vermont.
Farming.
yeah.
Farmers, we are offering a special legislative benefit that you can get out from under the ordinary rules of nuisance under certain facts and circumstances, if those facts and circumstances exist. And that's a very unusual kind of provision in the law. And so since it's a special legislative privilege being extended, I think there's some logic to the idea that one who wishes to invoke the benefit of that privilege should have the burden of showing that they qualify.
So that's where I was going with my question is the criteria for qualification on a farmer. Isn't that, I mean, what more? I understand, we're laying out these, we're loath to assign an agency with, laying out the correct practices and everything. So, we are assigning the special class, but we're not really making it very clear in terms of how to claim membership in that class.
I will just say that, there are clear arguments for and against extending the privilege. Once you extend the privilege, you have to figure out the criteria. And I just want to say that is a challenging task, and I have nothing to offer you on that because that is not something I've considered or studied or any expertise on. But I recognize, having followed this testimony, that is a challenging task. Not helpful to you.
Nicely
I was
done.
going to say thanks for nothing.
Nicely done. All right, thank you very much. It's a very helpful testimony. So.
I want more questions. No.
Well, thank you very much. I have some more
Yeah,
questions.
okay.
Yeah,
I'm thinking about water as trespass and there's probably a lot of questions. Lovely.
Well, water, I mean, there are all sorts of, as I say, all sorts of ways that government can trespass, low overflights, the government in a boat over on water that is private property, equipment, allowing people to pass. But water is sort of the quintessential government invasion. The government builds a dam, floods a whole lot of land. The government might have acquired the land under the reservoir by eminent domain, but they didn't bother to. So some of the very earliest takings cases involve people saying, you flooded my land, I'm entitled to compensation. And there are other cases involving more intermittent flooding, which would give rise to takings. I mean, the solution to this, the federal government deals with this all the time in the management of the Mississippi River. They have to deal with the risk of floodwaters. And in order to save New Orleans from catastrophic flooding and other cities along the Mississippi, the federal government has acquired flowage easements along the river. And in times of an enormous flood, they open special gates or they blow up a dike and water floods into these areas where the federal government has it's private property, but subject to a federal entitlement to flood those lands. And there are private flowage easements. I mean, one could imagine a situation where in this case, the parties could negotiate for the sale of a private flowage easement. And if the landowner sold that, then it wouldn't be a violation of their private property rights. But if they haven't sold that right, then it's a taking of their property rights.
probably need some of those along the Winooski River too, I think. Sure, somebody in government's pursuing those. All right, thank you very much.
Thank you.
Thank you.
So we're going to go to Scott Sanderson, but and if you, I just want to, I asked Michael Gray just to confirm what I thought, just to make sure everybody understands this as well, is that this bill won't affect the ongoing case that is before it, that we've talked about. That's unless we specifically say to notwithstand a provision that we have in our law that legislation does not affect pending suits.
Maybe to speak to that because I'm not sure that's entirely accurate.
Okay, all right. Well, so
I don't
Yes,
wanna
yeah, go ahead and speak to that, because that's an important issue.
I can be very brief.
Yeah, be very brief. Yeah, join us again and identify yourself for the record. Then we'll go to Scott. Sorry about that, but
In general, that's true. But in this case, there has already been, so there was a previous change to the right to farm bill after the trial concluded in this case. And the farm brought what is called a 60B motion, seeking to undo what the trial court had done on the basis of the change in the law. Now, in most cases, that wouldn't be something that applies, but because our case is in equity, meaning we have only requested injunctive relief, technically, they could ask the court to review it to determine whether it's still fair, given the change in the law. So I do think that is on the horizon, which means that all the legal challenges that we're talking about will come up very quickly if that is the case. And I do think that's the intention. I do think that's why this is being pushed.
well, we will explore that very question a little bit more with our legislative counsel as well.
I will eat my hat if we don't get a 60B motion after.
Well, you will definitely get a 60 motion,
Yeah.
whether it's valid whatsoever under our legislation is the other question.
Well, just again, it's because the question that needs to be examined is the equity question,
Right.
because it's not.
But if you have an injunction already based on this trial, then
So
that's
the argument,
disturbed, and we wouldn't want to disturb it.
the 60B argument will be because of this change in the law, it is no longer equitable that that injunction be enforced. That's why that's why the change is being pursued.
All right, well, good.
So,
Well, that-
thank you.
Got that clarification. All right, please join us. Scott, thank you for being here.
Jill, members of the committee. My name is Scott Sanderson. I'm the Director of Conservation Law Foundation's Farm and Food Program and a staff attorney. I also manage the Legal Food Hub, which is a free service that connects farmers to pro bono legal assistance and free legal resources. And thank you very much for the opportunity to testify on S45. So CLF opposes S45 because it doesn't seem to solve a problem. Mainly, nuisance and trespass lawsuits against farms are very rare and they don't threaten Vermont's farm economy. Moreover, as you've heard, S45 upsets the careful balance that has already been established by Vermont's existing right to farm law. It curtails property rights by extending right to farm to include trespass, and it limits Vermonters' acts or use of the courts when they have no other option to protect their property, health, and welfare. Now, I'd like to begin by affirming that Vermont's farmers face significant challenges, right? Those challenges include things like production costs that exceed farm gate prices, unfair federal pricing, insurance and subsidy programs, inconsistent regulations across the states, limited access to markets, accelerating farm consolidation, rising co-op fees and surcharges, rising land prices, right? It's a very, very long list. But one problem that usually doesn't make the list, whether that list was compiled by Vermont Farm to Plate or by the Vermont Task Force to Revitalize the Dairy Industry, is nuisance and trespass lawsuits. And that's because those lawsuits are just extremely rare. To my knowledge, the case that you heard about today and yesterday is the only nuisance or trespass case brought against a farm in years. And so to understand why, I think it's really important to discuss the purpose of right to farm laws and why Vermont's existing right to farm law kind of gets the balance right and is fit for purpose. So right to farm laws traditionally offer legislators an opportunity to calibrate the law of nuisance to the needs of communities where agricultural and non-agricultural land uses mix. And as you know, nuisance protects property rights, right? Specifically, it protects your right to use and enjoy your property free from substantial and unreasonable interference caused by your neighbor. And that's why it's often known as the good neighbor rule. But it's important to know that nuisance isn't about taste. It's really about harm. And the Vermont Supreme Court has underlined this point. It said that the unsightliness of a thing without more does not render it a nuisance under the law. Instead, a nuisance is a concrete interference with property as judged from the perspective of a normal person in the community. And of course, a normal person in an agricultural community knows that living in an agricultural community means accommodating farms. So a neighbor doesn't have a nuisance claim if they simply don't like how cows or manure smell, but they might have a nuisance claim if a farm activity threatens their health, for example. So an example of this is a series of high-profile nuisance lawsuits in North Carolina. And there, what became normal manure management practices on industrial hog farms, practices that North Carolina regulators did nothing about, created air quality problems that made homes that had been in families for generations nearly unlivable. And those community members dealt with chronic headaches, they dealt with nausea, asthmatic symptoms, and elevated blood pressure. And all of that was tied by scientists to the health issues. Those health issues were tied by scientists to the conditions that the farms manure, the surrounding farms. These are a lot of really big industrial farms, right? That these manure management practices created. And the community members, they weren't objecting to smells, right? They objected to being made unhealthy by their neighbors. Since regulators weren't willing to protect them, they sued a nuisance and won. And now, good right to farm laws, they're not supposed to shield farms from well-founded claims like that, right? Instead, they're really supposed to protect farms from unfair nuisance lawsuits while preserving neighbors' use of the courts when that use is justified. And in my opinion, that makes right to farm laws a very delicate balancing act, right? They're balancing a farmer's right to farm free from harassment with a neighbor's right to use and enjoy their property in good health and safety. And I think that balancing act requires two major considerations. The first part of it is balancing the outcome of a lawsuit, or is considering the outcome of a lawsuit that may actually take place. So how do you change the burdens and the criteria that are going to be considered as you move through litigation? I think the second part is how you're going to set up deterrence. So we've heard a lot of testimony about the cost of these lawsuits. In looking at a number of right to farm statutes, I've yet to see a statute that I think actually reduces the cost of ongoing litigation. Right to farm laws, they stack lots of criteria on top of the background law of nuisance and in some cases trespass, right? You heard about Oregon and I think Kentucky yesterday. And so in addition to the normal costs associated with litigation for nuisance and trespass, right to farm stacks more costs to deal with those additional claims. Now, what you get in return for that, if you're protecting farmers, is a deterrence value. So you hope that the lawsuit isn't brought in the first place. So there's sort of those two balancing acts, right? There's the balancing act related to the deterrence and the trade-off around cost. And then there's the balancing act related to the outcome of the litigation itself. Now, Vermont already has what I view as a good right to farm law that discourages unfair lawsuits against farms. It gives farms facing a nuisance lawsuit heightened protection if that farm can show that the activity alleged to cause a nuisance is consistent with relevant law, is consistent with good agricultural practices, existed before the surrounding non-agricultural activities. So that's sort of the coming to the nuisance idea that you just heard about, and has not changed significantly since the surrounding non-agricultural activities began. Again, that's kind of coming to the nuisance idea. And I think all of that makes sense. The idea is to protect farms that comply with the law, whose activities are agriculturally sound, and whose neighbors were on notice when they arrived in the community. And now I want to emphasize, and you've heard this before already, that this is all extra protection, right? It doesn't replace nuisance, it supplements nuisance. So if a farm fails to qualify for right to farm's extra protection or simply doesn't seek that extra protection, that's not the end of the lawsuit. They haven't just conceded the whole thing. The neighbor still has the burden of showing that the farm unreasonably and substantially interfered with their use and enjoyment of the property. Now, of course, that extra protection under the current law, it's not an absolute protection. Instead, it's going to force the neighbor to prove that the harm is uniquely severe. So you set up this back and forth. The neighbor would then have to prove that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with use and enjoyment of the property. And I think that's a much higher bar for the neighbor to overcome. So the idea here under the current law is that you set up a balanced back and forth, right? You give the farmer an opportunity to gain extra protection without stripping the background law out, but you also preserve the neighbor's ability to resolve particularly severe harms. And so I think that gets the balance right. And I think the evidence for that is essentially that you don't really see nuisance and trespass lawsuits. As you know, as you've heard already, the case that has been discussed is quite exceptional. I'm not aware of other cases in Vermont in the last 10, 20 years. I don't remember what the date is on Trickett v. Ox, but it's around 2 decades ago. Which is why, my example for a really solid nuisance case related to a farm, I've had to reach to North Carolina, right? So that being the case, I don't really think that there's a problem for S45 to solve. All the same, I do want to shift over to S45 which is of course the alternative that the committee is considering. And I think it proposes a couple changes that concern me. First of all, and again, you've heard this before, S45 expands right to farm protections to include trespass. And I think this would mark quite a dramatic policy change. It would also make Vermont a national outlier, since it is very rare for states to include trespass in their right to farm laws, right? I believe Oregon and Kentucky, those are the two states that I think were discussed yesterday, if I remember correctly. But for example, Vermont's regional neighbors, they don't include trespass in their right to farm laws. The law of trespass, of course, protects your right to exclusive possession of property. And I think it's the law of trespass that makes, for most people, that makes property what they think of as property. The right to prevent someone from using your property, from causing something like sewage to enter your property without permission. Of course, that's what trespass protects. And I think it does so, the way that S45 sets this up, I think that it does so in a way that could prevent Vermonters, including other farms, from invoking the law of trespass to protect themselves from farm activities that threaten their health or damage their property. And I think that's a major problem. And, we're thinking about this case where we have drainage related issues, right? The major problem, particularly given that EPA recently notified Vermont the state is failing to implement the Clean Water Act appropriately on farms. Now, expanding right to farm in a failing regulatory environment simultaneously leaves Vermonters exposed to potential water-related harms, like drainage that contains E. coli and that triggers toxic algal blooms, and takes away the tools that Vermonters need to protect themselves in the state's absence. Right? I'm not saying that this is the tool that protects Lake Champlain, right? I'm saying that for an individual Vermonter, this is a tool that they can use to protect themselves in the place where they actually reside. So I'd also highlight, of course, we've already heard this, that S45 may raise constitutional issues. I'm not an expert in constitutional law, so I certainly can't comment on that very accurately. You've heard some very, I think, compelling testimony on that. The second thing that I would highlight is that S45 shifts away from focusing on the harm caused to the plaintiff. That is core in nuisance and trespass. There's a big focus on the harm that somebody is trying to unburden themselves of. And so the way S45 does this is it essentially eliminates the back and forth that the current right to farm bill uses. And instead of giving the farm the opportunity to gain extra protection, it automatically blocks the nuisance and trespass claim unless the neighbor can show that a farm has violated a subset of Vermont's water quality laws, pesticide laws, or is engaged in an activity that's uncommon on similar farms. And if you can't show one of those things, it doesn't really matter if you've established evidence of severe harm, right? That's one of the, I think, well thought out parts of Vermont's existing law, is that you can overcome these protections based on traditional nuisance principles, but under a heightened bar, or you have to get over a heightened bar. And it also doesn't matter under S45 whether you establish, adverse effects on health, safety, or welfare. Your ability to protect property and health through nuisance and trespasses was quite cut off. Now, I will highlight that S45 does try to kind of reestablish some balance. It creates or clarifies that its protections wouldn't apply whenever a nuisance or a trespass violation results from the negligent operation of an agricultural activity. I'm not totally sure how much that helps. So my understanding is that when a defendant faces negligence allegations, a fairly standard set of defenses is going to be whether they are complying with relevant regulations and conforming with industry standards. So those are very similar to the fact of other factors in S45. And so in many ways, this may end up collapsing into sort of that regulatory argument that we've already that has been discussed in this committee already. Now, it doesn't completely collapse into that, but I think the thing that I'd like to underline there is it never goes back to the harm that the plaintiff is suffering. So it strips out that key characteristic of nuisance and trespass that focus on that harm. And so I think that's the second main problem here. And so
Yeah, I'm sorry. Go ahead.
A question about that. Are there other legal avenues available to plaintiffs who may be experiencing real harm, health harms, let's say.
I don't know the answer to your question. I think these would be the most natural ones if it fits the facts. And so if you are dealing with an example like the North Carolina lawsuit, where you have a state government that has essentially decided to ignore your problems, even though you're facing substantial health issues, the natural claim there is nuisance. Nuisance was built to deal with that kind of a problem. Similarly, if you have drainage or flooding issues that are leading to contamination of your property, and, that may itself lead to health problems that you have to deal with. Again, trespass was well tailored to that particular problem. And so I don't know. I'm sure there are other ways that you could find your way into court. I don't know what those would be. But these are the causes of action that are, as I understand it, designed to deal with that problem.
Okay, well, that's interesting to note, seeing as we've heard so many times today that these cases there aren't a lot of cases like this in Vermont. Just interesting.
Right, and I think that makes sense, right? There aren't a lot of cases because folks aren't having a lot of problems, and because the existing right to farm law is doing its work deterring the unmerited cases, right? It's sort of its role is to cut off the cases that would be frivolous, that would basically intimidate a farm into complying with what a plaintiff who has unreasonably brought a lawsuit wants.
Tom, did you?
Yeah, just quick. You think about the very nature of farmers farming and their neighbors and the fact that, well, put that aside, that they try to work things out with their neighbors so that they have the laws generally.
Absolutely. I mean, with the Legal Food Hub, we often are placing farmers who have disputes with their neighbors and working with them, or putting them in a position where they can negotiate that well.
And I could probably ask everybody the same question, but the nature that farming is a very rural activity. They're not surrounded usually by a lot of people. But now that farming is it's evolving. Some farms are getting bigger, others are disappearing. There's lots more development on some of this rural land. That it's potential that these complaints could accelerate.
It's always possible. I think that's why I bring up the background of how nuisance law works and the standard that's there, right? The standard of a normal person in that community. And if it's an agricultural community, that requires some sort of familiarity and recognition of what it is to be in an ag community, be that smell or things like that. But I think that doesn't, changes in how the land is used and working. It doesn't, I think, relieve community members from that sort of basic duty to look out for one another. And I think that is sort of what nuisance and trespass are about. It's about, looking after your neighbors to some extent and making sure that what you're doing with your land isn't harming them.
But we have to make a balance too of watching out for the neighbors and protecting stuff that is historical and just Vermont as well.
Absolutely.
I think policy decisions could help that. I don't know if this is the right spot, but anyway.
So it seems, I mean, that was mentioned earlier, that coming to the nuisance concept. So if you have a farm out there and they're moving development into there, that farm was there first, and the nuisance was there first, and you're not going to be able to be successful on a nuisance claim. So that kind of deals maybe with somewhat of the concern of expanding development.
And I think as highly regulated as farms are from other aspects from the state and from the federal government, and I know for a fact in my world in law enforcement, I have dealt with a lot of nuisance issues with farms, but they're always remedied usually very easily. Sometimes there's a reoccurring. Okay.
Yes, go ahead. Oh, did you have more were you finished? I don't know.
I think I may have been. I
think we jumped into a question because
maybe the questions were timed perfectly because I ran out of stuff. So
fair enough. Any other questions? Not seeing any. So I think because we're gonna have a very, very long day this afternoon, I'm gonna reschedule you to next week, John. And we'll have Steve back as well. And whoever has more to say, we'll have them as well. So probably next Tuesday afternoon, we'll get back to this. But give us a little bit longer break before being on our butts for hours this afternoon. Do you have anything else with you?
Not to the witness, just on this though.
Yeah.
Can this be one of our bills that we have some time to discuss in committee?
I got these.
Yes. I think we'll schedule discussion in addition to these two witnesses as well. And if there's other witnesses, if people think of other witnesses, I don't know if we need to bring in any individuals who've been sending us emails. I think that we're getting that from the folks, right? So, who knows on that?
Anyone from the judiciary?
I wondered about
Yeah,
that.
we'll probably bring in Judge Delaney as well. Yeah, we need to do that. And we'll have Mike back to talk a little bit about the impact, if any, on the current lawsuit and Rule 60B and the like. So